All right, let's talk about private equity and antitrust. I'm Jack Pace, she's Heather Greenfield, and we're both members of White & Case's global antitrust practice. So, Heather, you and I both do work for private equity companies, and I have some concerns, and frankly, I think our clients might have some concerns if they read the newspaper. As we both know, private equity can be and is a really important part of the economy, and it's getting more and more important. The McKinsey 2022 study on private equity, for example, they reported that private equity investment had not only returned to pre-pandemic levels, but I think assets under management had risen to something like over $6.3 trillion globally. However, as we all know, that has gotten the attention of the antitrust authorities. And I'll just give you one example about that, and then I have a question. Lina Khan, chair of the FTC, she said the following about private equity and competition. She said, quote, "The growing role of private equity and other investment vehicles invites us to examine how these business models may distort ordinary incentives in ways that strip productive capacity and may facilitate unfair methods of competition and consumer protection violations." So the question for you is, what should private equity firms, their counsel, their consultants do and expect in light of all this new attention?
Well, what I would say to start is a lot of this is not new. Private equity firms are not new. The model of private equity is not new. And it's not new that the agencies are looking at private equity firms. Let me give you two examples. First, HSR filings. There have been proposals to increase disclosure requirements in HSR filings. Generally speaking, private equity firms disclose investments across funds on the HSR form. And just a couple of years ago in 2020, there were proposals under different leadership, different administration to increase disclosure requirements. So we understand this, and a lot of this is not new. Secondly, Section 8 interlocking directorates. Just in early March, the DOJ announced more resignations. Section 8 has been around for a long time. We know the defenses, we know the arguments, we've been advising clients on this for a long time, and it is manageable with the right safeguards and the right preparation. You can implement officer and director questionnaires, change of employment policies, where you can really monitor this. So yes, there's increased buzz, there's increased scrutiny, but this is manageable, with the right preparation, and it shouldn't be pencils down in the boardrooms for PE firms.
Okay, let me test you on that. I've come prepared. So I took a look at some of the literature. The economists have something to say about this. And let me give you two examples from the economics literature and then pose a question to you. So a group of economists published a study in February 2021. They took a look at nursing homes, first of all. The nursing home study has gotten a lot of attention. And one of their findings reads as follows: "Our estimates show that PE ownership increases the short-term mortality of Medicare patients by 10%, implying 20,150 lives lost due to PE ownership over our 12-year sample period." The same economist, the next year, 2022, took a look at local newspaper ownership. And they found that PE firms owning more local newspapers led to a few interesting things. Less local coverage, but importantly, less local coverage ended up meaning in their study less participation in local elections. So now, Heather, we're talking about mortality, democracy. So what I would want your help with is, imagine I'm going into a meeting at one of the agencies. What do you say if you're trying to defend a PE deal and they throw one of those two studies at you?
I would say, DOJ, hold on, let's take a step back. This is more complicated and nuanced. It's not that simple. First and foremost, this is not necessarily an antitrust issue. The antitrust authorities should not be picking winners and losers based on a business model. They should be looking at the competitive impact, the competitive issues of a transaction under Section 7. And here, the research shows that PE firms can increase competition, that they respond better to competitive incentives, and PE firms increase productivity, they can improve poor management, they can increase innovation. These are all benefits that go to consumers. Relatedly, we have to ask ourselves, what is the alternative for some of these companies? What is the but-for world? PE firms, in many instances, are coming in and they're saving companies. Some of these companies would fold. And in the case of newspapers, a lot of newspapers are struggling. And the research shows that PE firms, they increase digital access and they decrease the chances that some of these newspapers will fold. So to me, the question is, do you want no newspapers or do you want some newspapers with digital access?
Okay, then let's shift gears a bit to the courts, because I understand courts have started to rule on some of the recent agency actions directed at private equity. And I guess the question, Heather, is what do the recent court decisions tell us at all about whether the agencies may or may not be overreaching in private equity?
There is a recent DOJ loss in United Change in the healthcare space where the parties had a divestiture buyer that's a PE firm. And as background, both agencies have come out pretty strongly disfavoring private equity as buyers for divestiture assets. The judge rejected the argument that just because, the buyer is a PE firm, that it lacked incentives to grow the business. And the judge found that the private equity firm, had shown that it will maintain the business, but also grow and improve the business. So I think the courts, are coming out on the other side of the agencies. And my question for you as a litigator is, what do you tell private equity clients where maybe the litigation risk is lower, but they still want to avoid the enforcement risk? Investigations can still be long and costly.
It's a good question. I'll start by saying I'm old enough to remember U.S. versus Microsoft, Heather, the government's attack against Microsoft and the litigation that followed for several years. And in the D.C. Circuit's ruling in the Microsoft case, the court there said something very important. They said that antitrust courts have an obligation to try to craft rules that are sort of clear. In other words, that guide conduct and tell companies and parties what to do. I think that same rule applies to the agencies. I think the agencies have a special obligation to try to be as clear as possible and avoid, where they can, taking positions that are dramatically different with the law everyone's relied on. So what I would tell clients is that we can help navigate that uncertainty, but it's also might be worth the fight. In other words, you can win. And so you can win in court, you can win some of these battles. And so just because you're being investigated doesn't mean you need to just fold. You can fight and win, like the case you cited just tells us. So I guess let's try to be as practical as possible here. Based on your work in this space, what is some free advice you might give to our viewers about how to navigate one of these deals?
So here are two practical ways I think parties can mitigate the antitrust risk. First, we know that the agencies are focused on PE roll-ups. We know that they're focused on successive transactions. So document creation is really key here. PE firms and companies should be careful about what is being put in their documents, particularly the documents that are going in with HSR filings or maybe part of other investigations. When a PE firm is creating documents to analyze a transaction, I would advise that they stick to the transaction at issue and not include information on future pipeline transactions or robust M&A activity, particularly in the same industry. Second, it's key and important that the M&A team and the antitrust team stay coordinated on what risk the PE firm is willing to take in the commercial agreement. Today, parties often carve out obligations to make divestitures or to go to litigation to get the deal done. Given some of the FTC policy changes, including imposing really burdensome prior approval requirements and consent decrees to parties agreeing to divestitures, and these prior approval requirements, they require a party for the next 10 years to get FTC approval for transactions in the same industry for deals that otherwise would not be HSR reportable. This is an obligation that many PE firms and companies do not want to take on. So similar to how companies carve out divestitures or litigation, you can insert clauses in the merger agreement to carve out this type of obligation.
That's helpful. Are your private equity clients still doing deals? Should private equity clients still be aggressive in doing deals?
Yes, antitrust should not be a roadblock to doing deals. There are strategic opportunities, even in the same industry, and this is manageable with the right strategic counsel and preparation.
Okay, that is good to hear. Then I think I'll end this session by bringing us back to a case. The Supreme Court, Arizona versus Maricopa. It's one of those good Justice Stevens antitrust opinions, 1982. There, Justice Stevens held, essentially, that there's just one Sherman Act. It doesn't vary by industry. We all have one Sherman Act that we have to share. And I think I would remind parties of that if they're trying to create different Sherman Acts or different sets of antitrust rules for different industries. So I think that's a good place to end. On behalf of Heather and the entire White & Case antitrust practice, thank you.